Good morning. This is Nick Brown. I'm a trial attorney at Bernheim Kelly. I'm here to give an update on what's going on with the Bair Hugger litigation. So for those of you know or don't know, Bair Hugger is a warming device that the 3M company based out of um, Minnesota manufacturer for folks in undergoing implant surgeries or really anything in the hospital. I mean, they can use these devices to um, keep people warm anytime they're in an operating room. And they've been developing and manufacturing this device for decades. And recently, what's come to light is that these devices cause infection or increase one's risk of infection. And so there are plenty of YouTube videos. I actually put that in the links. There's a great video that sort of shows how the Bair Hugger device works and how it increases one's risk of infection during a procedure. Most of our clients have either undergone a knee implant procedure or a hip implant procedure, and then shortly thereafter incurred an infection, then had to go through the whole um, infection management process to help clear that up, whether it be eventual amputations or a simple debridement procedure where they go in, they wash it out, they either put in antibiotic beads, or they in some cases they had to do a two-stage revision. But the point is these people went in for a hip knee implant procedure. The Bair Hugger device was used during that procedure, and the folks incurred my clients incurred a infection thereafter, and then had to get treated for that infection. And so the Bair Hugger device is used because in the operating room, it's very cold in there. They have industrial air conditioning units where they're pushing cold air down onto the client during the procedure, and then they have ventilation systems, around the perimeter of the room. And that's pretty typical operating room. Obviously, it varies from hospital to hospital, but that's the general idea is that you've got continually circulating air to help decrease the bacteria and germs and ultimately help keep the patient safe. But with that comes a risk of hypothermia, and so they don't want patients getting too cold during a procedure. It causes a whole host of different problems while the patient is under anesthesia. And so the Bair Hugger device, they wheel it in, and it's essentially forced hot air through a blanket. They put the blanket on the patient, and it helps keep certain portions or parts of their body warm. Perhaps keep their core warm during the procedure so that they don't risk a chance of going into hypothermia. And so it's a pretty interesting trail. The procedural history here is pretty interesting. The first cases were filed, I believe, in 2013, and after a few cases across the country were filed, the JPML met and decided this case was going to go before a U.S. District Court for the District of Minnesota, and Judge Erickson has handled this litigation since the start of what's called MDL. And Judge Erickson effectively dismissed all the claims. She granted the defendants motion to exclude the plaintiff's expert witnesses, and also granted the defendant's motion for summary judgment in 2019, which effectively dismissed all the cases. Plaintiffs appealed that to the Eighth Circuit, and in 2021, the Eighth Circuit overturned Judge Erickson's decision, which effectively sent the case back down to the District of Minnesota with Judge Erickson for further litigation. Interestingly, 3M actually filed a petition for certiorari with the United States Supreme Court, and the U.S. Supreme Court declined to take the case, which effectively sent the case back down to Judge Erickson. And now the case has been stayed since 2021. We've been taking clients, we've been teeing these clients up for litigation. But what that means is we can't do much past filing complaints and getting everyone's plaintiff fact sheets submitted while leadership is still negotiating behind the scenes and, trying to put together a settlement grid that would, work for most clients. And most recently, um, there was a mediation where, and this was earlier in June of this year, the parties are in an impasse. The negotiations have stalled, and the plaintiffs are valuing the cases higher than defendants are, and the parties essentially agreed to randomly select 250 cases for the purpose of trial, and hopefully this will um, help the parties get a sense of value. I mean, that's the problem right now is, we're valuing the cases higher than they are, and there's no settlement. There's no options. And bellwether trials were a little shaky for the plaintiff's side the first time around. And so the mediator recommended that the cases that the parties find a way to agree on going back to trial. And so the process is there are 250 cases that were randomly generated. If you are one of the 250 that my firm has, then we've already reached out to you. You know who you are, and we've gotten the authorizations that we need that they've asked for. And the next part is to whittle those down. The 250 is ultimately whittled down to 34 cases, which will proceed to trial. Now, the question remains of where those cases are going to be tried. We want to get, we've pushed for remand. So what that means is wherever the plaintiff's original jurisdiction is. If I have clients in Alabama, clients in Massachusetts, clients in Texas, wherever that original jurisdiction is or wherever that venue is, we want the cases remanded back to their home state for trial. The cases in Minnesota, that's 3M's backyard, and for I think with pretty obvious reasons, we don't want to litigate there. The bulk of those cases if we can help it. One thing that Judge Erickson did that really is, I'm anxious to see how this plays out, but we originally pushed for all the cases that all 34 to get remanded. Obviously, the defense, they're in 3M, that's their backyard in Minnesota. They want to try all the cases in Minnesota. It's not clear which way Judge Erickson's going to go. The most recent order, which is a July 2023 order, just essentially forces the parties to, or pushes the parties to get down to the 34 cases. And then once those cases are established and we've shown that they're viable and that the clients want to move forward, the next step is figuring out where these cases are going to be tried. And so it's teed up for progress. I know a lot of folks have been frustrated because there's been no movement. But that's one of the things that we've been pushing, we've been working on, we've been mediating with 3M to try and get some movement and get the stay lifted, or push 3M in a position where they're willing to actually have a real negotiation. And so if you have any questions, if you've had hip, knee implant procedure and you got an infection thereafter and had to have a second surgery, then definitely reach out. I'm happy to have a conversation about it. I can explain what we're doing, our approach, our strategy to help get these cases some sort of resolution, whether that's a trial or whether that's a settlement. But that is where 3M Bair Hugger device currently stands. Don't hesitate to reach out if you have any questions. Thank you so much.